Good afternoon, everyone. Welcome to the ITCU webinar series today. We do have a couple of polling questions that we have up. So if you would take time to answer those, if you would like, we're going to give everybody just a little bit more time to get logged in, and we'll be back with you shortly. Okay, I'm going to go ahead and I'm going to leave the poll up for just a couple more seconds, but we're going to go ahead and get the introduction part done. Good afternoon and welcome to, again, the ITCU webinar series. I'm Rufus Guidry. I'm the Senior Manager of Marketing here at InTouch Credit Union and one of the counselors. We're lucky enough to have with us again, Rehan Hogan. Sorry. Rehan is the CEO of Silvur, which provides members like you with retirement calculators, tools, and education through Retirement Simplified. Prior to Silvur, Rehan worked for 17 years at JPMorgan Chase, where she advised individuals and families on investments, credit, and wealth planning. We're thrilled to partner with Silvur on this exciting free member benefit. Today's session will focus specifically on trust and estate planning for retirement. We would like to ask that all questions please be asked in the chat feature, and we will get to them at the end of the presentation. Rehan, I'd like to turn this over to you.
All right, Rufus, thank you very much. And thanks to everyone, all the members at InTouch Credit Union for joining the session today. As Rufus mentioned, we're going to be really focused on estate planning and retirement, and it may be, and we'll see what the results are from the survey, that some of you have done some estate planning already. But what we know is that life changes, there are plans that evolve over time, new family members, et cetera. And particularly as you get close to navigating retirement, it's an opportunity to really just take a look back at that estate plan. If you have one, refresh it. If you don't have one, to really think about now is a great time to get started. Before we kick off, just one kind of word of warning is that I am not a tax professional or financial advisor. And so we're really going to be sharing here are tips to help you get started. The team at InTouch is here to dive deeper with you with specific questions that you may have. And many of you may be working with a trust and estate professional who also can guide you on the specifics. But before we get started, let me just introduce Retirement Simplified, which is powered by Silvur. As Rufus mentioned, this is a free member benefit offered to members of InTouch Credit Union who are over the age of 50. Our goal at Retirement Simplified is to really help guide you through the big decisions you'll be making at retirement so that you can live your best retirement. At the heart of what we do is we provide every member with a retirement score. You can think about this as like a FICO, but for retirement. For many members, it answers that big question, which is, do you have enough savings to last a lifetime? Through the retirement score, we help you understand big decisions like Medicare, Social Security, how much you can spend in retirement. If you're thinking about if you're thinking about moving, understanding how moving might impact your score. So all of that comes with a score. In addition to tools and calculators, we have a lot of educational topics on things like Medicare, Social Security, taxes, cost of living, inflation, estate planning. Actually, today we're launching a new series on estate planning that's really focused on estate planning on different marital statuses. So understand the differences, for example, of estate planning if you're single versus married versus divorced or in a partnership. And so really hoping that, through Retirement Simplified, you're getting that personalized education that meets your specific journey that you're on. All right, so let me tell you what we're going to cover today. And then Max and Rufus, if we're ready, we'll load up the answers to the survey so we know where everyone is when it comes to estate planning. So a couple things that we're going to cover today. The first thing we're going to just discuss is why a will or a new will is important during retirement. And again, just understanding kind of where you are on this journey. We're going to talk about the role of a power of attorney and how to think about choosing someone. We're going to speak about beneficiaries, how on certain accounts you can name beneficiaries, and that can actually make your estate planning even simpler. We'll talk about some of the basics of trusts and when not it may be irrelevant for you. We'll talk about how where you choose to live could impact your estate plan, and if you have moved since you put in place, for example, a will, how you may need to revisit it depending on where you've moved to. We'll talk about that dreaded word, which is taxes. So how do we think about taxes around estate planning? And then I'm going to end with a couple of tips that are specific to different marital statuses. We're going to today cover single, married, divorced, and we'll talk about partnerships as we go through all of those to really make sure that depending on your specific situation, that we're giving you the information that you need. So if you can just hold with me for 1 second, I'm going to just reload the webinar so that we can get the survey results in. So give me 1 second. Okay, it looks like our survey results have not been loaded up yet, so I'm going to skip past it and we're going to come back in a second. So let me get my screen share going again, and we will load back up the webinar. All right, so let's talk about some of the basics. And again, as Rufus mentioned, as we go through this, we are going to take questions. So I would really encourage you to throw questions in. No question is too simple or complex. There may be situations where it's a very fact-specific pattern that we won't be able to address on the call, but we'll do our very best to address it afterwards. So again, get those questions in to make sure you're hearing what you want to hear. So let's talk about why having a will is important. At the heart of it, it really ensures that your hard-earned savings go to the people and the places that you want them to go to. I say people and places because it might be that you have children or grandchildren or a family member that you want assets to go to, but you might also have a charity or another organization that you're looking to bequeath assets to. Having a will specifies who gets what. It's a great way to protect family members, to both ensure that the specific family members that you want to receive assets are getting them, and also to determine when they receive assets. I think for those of you that may have children and created a will when kids were younger, you probably thought a lot about what age you wanted children to have access to things. That can still be the case when you have adult children. And so really thinking about not only who is receiving the assets, but how much and when you want them to receive. The risk is that without a will, your state will determine where your hard-earned savings go to, and the state may not know, for example, the family dynamics of your situation. And so it may be that you have a very particular point of view on how you want your assets distributed. And without a will, you are really leaving it up to the state to determine how those assets are divided. So some of you on the phone may already have a will. And so I know my expectation is that you've joined because you want to learn more. But what I would just say is that if you already have a will, congratulations on gotten started. But would just also say to you that, it's also a good opportunity to reflect and just make sure that life changes were accounted for. So it could be perhaps as a change in marital status, you could have gotten divorced, you could have gotten remarried. It could be a change in, I would call it like adult children's needs. So, your kids when they're 10 are very different to your kids when they're 30. Some challenges may be obvious when they're 10, other challenges become more obvious in their 20s and 30s. And so really thinking about what the needs are, if you have family members that you're providing for. It could be that you have grandchildren, and making sure that, all of them or some of them are accounted for, depending on what your specific needs are. And also you may have moved, and really and we're going to talk a little bit about why moving matters, but the rules are often different in different states. And so just making sure that you're aware of the specifics of the state that you're moving to will be important when it comes to having a will. So I always say it's a good opportunity to refresh your will or to look at your will, once a year, and just make sure it's still addresses, your goals, rather than kind of doing this once and never taking a look at it again. So there's a lot of different types of wills. Really quickly, just to kind of talk about a couple of them. At the most foundational level, it's what's typically called a simple will, which documents how your assets are disposed for. If you have children or pets, and the children are of an age or of a need where they need additional supervision or care, that you would document that through the will. A testamentary trust is a trust that's actually created out of a will. It could be that you're directing some of your assets or all of your assets to be held in a trust for beneficiaries. I know, for example, in my family, that is something that my father has done, that he has put some assets in a trust for beneficiaries, and he really thinks about that. And we're going to talk a little bit more about special needs trusts, and there may be specific reasons why you don't want the assets going outright, but you actually want the assets to go into a trust and have someone controlling how the money is distributed over time. Often cases when you don't want someone receiving a lump sum, but you want them to receive an income stream over a longer period of time, is when you want to set up that testamentary trust. A living will is quite different to those first two items. A living will is really about documenting the type of medical care you want if you're no longer able to make those decisions yourself. And so oftentimes this is, really considered like a health proxy is another name that's used for a living will. So making sure, again, that if you put one together a while back, that, you have the right people today in your life that you want making those medical decisions. And then finally, certain individuals will decide that instead of having a simple will, if they're married, they may choose to have a joint will. This basically allows for identical beneficiaries and provisions for a couple that is creating a will together. The one thing I would just flag is that it is fairly inflexible, and so when one partner passes, the remaining partner cannot change the will. And so if you want to have more flexibility, you'd really want to use more of a standard will rather than the joint will. So what will is right for you? Now, this is one that's really hard for me to answer without understanding the specific facts and circumstances for the folks on the phone today. But I'm just going to throw out a couple things, which is, really understanding, whether your children have grown up and whether you're really trying to document care for children or grandkids. Understanding whether your marital status has changed since your will was last updated. And so really thinking about, does that will actually reflect your current marital status? Understanding whether the will has been set up in a way to protect a surviving spouse, really making sure that that surviving spouse has access to the assets that they're going to need to provide for their care. One thing to think about for folks when you think about surviving spouses is that typically the surviving spouse will actually have higher healthcare costs than the spouse that dies first. That's often the case because a spouse that dies first many times will be cared for by the other spouse. But when you have one individual alive who's either single or is a widower, they're often needing to pay for care. And so really thinking about that as you think about how assets are split up. Understanding whether you have assets either in total or parts that you want to go to a charitable organization. And then finally, really making sure that if you have pets, that you've thought about how they will be cared for after you pass. Again, it may be that you didn't have a pet when you put together your will the first time, but you may be one of those individuals that got a pet during COVID. And now really making sure that they are accounted for in your will is going to be important. Let's talk a little bit about power of attorneys. There's a couple different types of power of attorneys. Let's start first with a general power of attorney. And that really the idea behind a power of attorney is it's giving someone else the ability to make decisions for you. The general power of attorney is really responsible for taking care of the financial, business, legal issues on your behalf, whether or not you're incapacitated. So it could be that you just don't feel comfortable with money. And you've said, look, I want to give a power of attorney to an adult child who's going to make these decisions for me or for us. And so, or it could be that you're putting that power of attorney in place, and we're going to talk about that in a little bit, which is with limited authority. So like if you are incapacitated, that's when you want someone else to be able to make those decisions. So the durable is really that second variation, which says, look, I right now feel comfortable making these real estate, financial, business decisions, but if I'm unable to, I want this family member, friend, adult child to make these decisions for me. And so the durable, you can think about as being almost that carve out, that if you're not able to make decisions, that they can make decisions for you. Medical type of power of attorney is often called an advanced directive or a healthcare proxy. This is what, again, allows someone else to make decisions about your healthcare or medical treatment when you're not available or you're not able to actually make those. And so these become really important. And you're, particularly when you're documenting the types of care you want and don't want, it really, I would say, provides some relief for the individual that's acting as the medical power of attorney, but also ensures that your desires are being taken into account for when you document all of this up front. Limited power of attorney is very similar to what we've talked about, which is it's designed to act in certain ways with the limited authority. So you're kind of giving a more narrow scope on what you want that power of attorney to actually do for you. And then finally, the concept of springing is a springing power of attorney only applies when something happens. So it could be that like only happens when you're in the hospital or only happens when you're traveling. So you really specify the circumstances under which you want that power of attorney to be in place. So the power of attorney that gives someone probably the most, if you want to call it power to make decisions, is that general. As you start thinking about the durable, the medical, the limited, and the springing, you're kind of refining the time periods in which, either the time periods or the types of decisions that you want this third party making. So again, that's, I think, really important to consider, which is, how much authority do you want to give someone else? And under what circumstances are you actually giving them those rights? So let's talk about how to choose a power of attorney. Oftentimes folks think about, an adult child, it could be a close friend, spouse, partner, or someone else that they trust. It's helpful to think about someone who perhaps is a little bit younger than you, just to create some age differential. So you're not in a situation where you're giving your power of attorney to someone who ultimately themselves, passes before you do. A couple key things to think about when you're thinking about the power of attorney. They do have a lot of responsibility and in many cases autonomy to make decisions. And so you really need to think about how trustworthy are they, or do they really align with your goals? Proximity can be really important, particularly when you think about healthcare proxy. So giving your healthcare proxy oftentimes to the child who maybe lives closest to you can be a more effective decision oftentimes than perhaps the child that lives furthest away. Obviously, there's specific circumstances around like which child you might want having that right. But again, just thinking about particularly for the healthcare proxy, someone who can actually be reachable and in person to help with those healthcare decisions can be important. And then particularly if you're doing a general power of attorney where they have oversight over your finances, you really want them to be good with money. You want them to be responsible, fair, and comfortable, really dealing with the money in your estate. It's something where I would also say, having a longer conversation with someone and bringing them into the equation earlier so they understand the responsibility you're asking them to take. So they're not surprised to find out that they have the power of attorney or feeling that like they actually aren't capable themselves. You want them to really feel like they're comfortable taking on this position for you. So let's talk about beneficiaries. There are a lot of your investment accounts, you have the ability to add a beneficiary to. And so it may be that you've added a beneficiary in the past to a 401k account, or when you opened your account with InTouch, you may have added your beneficiaries at that point to your accounts at InTouch. The beneficiary is someone that's listed on that account to receive the assets when you pass away. So in many ways, just think about this as being almost outside of your will. You're basically saying that the beneficiary of this account is actually going to be this specific individual. Important to think about who you've signed up as beneficiaries for accounts when you then start writing your will. because the beneficiary, again, accounts that have beneficiaries on them will actually be excluded from the will. So important that you don't end up kind of doubling up on assets that are going to people when you think about who you've added as beneficiaries versus the will. The reason many folks use beneficiaries is that it allows the money to go automatically to that beneficiary rather than going through probate, which is the process by which the states actually settle your will. And so if you're looking, for example, to make sure that people have access to cash in your account to pay for a funeral or to pay for healthcare expenses, really making sure that there's a beneficiary on accounts can speed up the time in which it takes for a beneficiary to actually access the account. It really can speed things up from it being, a matter of a few days to a week to be able to access funds, to extending that period to almost a year. And so the beneficiary, if you really want to make sure that you have money that's accessible to heirs, assigning beneficiaries is probably one of the most important things that you can do to smooth out that estate process. All right, so how do you designate beneficiaries? The first thing you want to do is you want to take a look at all your investment accounts. I did this with my dad a couple of years ago, and the first thing I said to him was we needed to start consolidating accounts. Unfortunately, we don't live in a state where there are In-Touch Credit Union branches, but if we did, the advice would have been really think about like who that primary financial relationship is going to be with. In the case of In-Touch Credit Union, working with the team to think about the consolidation of those accounts, that can be really important because having too many accounts open can make it very challenging down the road for folks to actually be able to find your assets, make sure that they can access your hard-earned savings. And so we went through this process where we made a list of accounts, we figured out which accounts we were going to shut and consolidate. And then we wanted to assign beneficiaries. And so my dad assigned beneficiaries for the different accounts, really thinking about the values that were in the different accounts. You can assign primary and secondary. You can assign multiple beneficiaries. So you can say, look, this account is going to be split equally between two folks, or it can be, it goes to one person. And if that person either disclaims it or isn't alive, then it goes to the next person. And so you have that ability to really think about almost like a structure or a waterfall in how those beneficiaries are named. Don't forget your retirement accounts. That's like actually the easiest one to put your beneficiaries on. Oftentimes you can actually just do that online through your retirement account provider. Again, and this is where, again, you may have, again, this concept of a waterfall. I know for myself, I have my husband as the primary beneficiary for my retirement accounts, and then I have my kids as a secondary, and I have 2 children. And so I've split it 50-50 between those 2 kids as the secondary beneficiaries of those retirement accounts. Again, do that, doing that can help you avoid probate and just can kind of create a lot of simplicity, which is helpful. A couple other tips I would just say, and we've kind of gone through this a little bit, which is make sure your spouse is listed if you want to give it to them. And so that's in my case, I said I listed my spouse first, added the second beneficiaries. In my case, again, I added my children as a secondary. And again, review it periodically. Like the change I made a few years ago is I had a second child. And so instead of having 1 secondary beneficiary, we switched to having 2 secondary beneficiaries. And so really just reviewing it periodically to include, just thinking about family births, deaths, divorces, particularly if you've gone through a divorce, you'd hate to find out after the case that you had listed an ex-spouse as a beneficiary for a specific retirement account and actually didn't want them to receive it anymore. So really important to do that cleanup on beneficiaries once you set it up, because if you don't make those changes, those assets will flow to those individuals. All right, so let's talk about when a trust makes sense, because I think there's probably a misnomer out there that you need to be really wealthy for a trust to make sense. And oftentimes folks that are very wealthy, are doing a lot of planning with trusts, but there are other reasons that you might want to consider a trust. So the first thing is just legal protection for assets. So it may be that you have an adult child that you want to make sure that there's no creditors that can access assets on behalf of your beneficiary. And so just putting an asset in a trust is a way to make sure that, if a child, for example, files for bankruptcy, that those assets aren't pulled into the bankruptcy. If you're looking for some specific kind of distribution of assets after you pass away and over a different period of time. So, again, the more that you don't want the money just distributed straight away and that you want some sort of like timelines and processes. So you want someone to receive, instead of receiving $200,000 all at once, you want them to receive $20,000 a year for 10 years. that's when kind of a trust can make sense. It often can help you divide up assets like RVs and vacation homes. So it allows, instead of having to force to be sold the RV or vacation home, it can give folks a share or in those RVs or vacation homes. So you allow for the asset to continue to be held by the family, but people to have pro rata shares in the asset. In certain circumstances, it can avoid probate. And again, because the more you document, the more you can avoid the probate. It can, in certain cases, reduce estate taxes or inheritance taxes. And then for those of you that have adult children or maybe even grandchildren that have special needs, a special needs trust can be really helpful. And we're going to talk a little bit more about kind of where those trusts can make the most sense. So let's talk a little bit about the different types of trusts, because again, there's a lot of different variations, and this is just 4, I'd say, of the most common trusts, but they're, if you were to sit down with a trust and estate attorney, they could give you the specifics on what makes sense for your fact pattern. The first is a revocable trust. This is a trust that is really flexible. It means that it allows you to put assets in the trust during your lifetime. The fact that it's revocable means that you can change things. It can help avoid probate, but there are no tax or creditor benefits. And so, in that fact pattern I was talking about kind of a bankruptcy, that doesn't really help in that particular fact pattern. An irrevocable trust has less flexibility, but it can have some benefits associated with it. So once you set up an irrevocable trust, it's really much more challenging to change, because you're basically almost giving up your rights to make decisions on it. So you're saying, look, I'm revoking almost my ownership of these assets. Many families with higher net worths will use these type of trusts to try to help protect some of the assets from federal estate tax purposes. It may also be that you're selling a family business and there are specific reasons why you want to make sure that you no longer have access. Maybe you're going to say, I'm going to live off the income, but I don't have access to the principal anymore. And it's a very specific tax strategy that you've put in place with your accountant. The special needs trust is one that's used very frequently for family members, where you're looking to make sure that there's money set aside to perhaps buy them a house or take care of them as they age. Special needs trusts are often used as a way to ensure that family member still can get access to Social Security and Medicare, without being disqualified because of their assets. So from those of you that have either have kids or grandkids or special loved ones who have special needs, you may be aware that many of the services for Social Security and Medicare are income based. And so a special needs trust is a nice way to be able to maybe provide that lump sum to provide some extra protection for that individual while making sure they can actually still access Social Security and Medicare. And the last thing may be that, like, if you've got children, that the kids are set up, but you want to make sure that you have money that's set aside for the grandchildren. And so you can set up what's called a generation skipping trust that allows you to get money to that next generation. I see that we've got our first question in the Q&A. What I'm going to just say and ask is that if everyone can keep getting those questions in, and I'm going to address them all at the end, but please keep sending in those questions. So we're going to move over to one of my, I would say, favorite topics, which is where you live matters. And I think there's many things about where you live that matters, like closeness to family and friends, the types of weather, the types of activities you like to do. But I would just say that in retirement, where you live could be the difference between, in this particular case, we're showing your savings lasting until you're 80 versus your savings lasting until you're in your mid 90s. And that's because I think, as folks on the phone know, taxes can be very different depending on where you live. I think folks that live in Nevada are very aware of that state line with California and what the tax implications are of crossing that state line, and really thinking about, as you navigate retirement, what that means for you. So where you choose to live in retirement could be the biggest retirement decision you make, both from a social and lifestyle perspective, but also importantly from a financial perspective. That comes up specifically also as you're thinking about your estate plan. So one of the things I just want everyone to really think about is that if you have moved since you created your will, really just taking a quick look back to make sure that the plans you put in place actually still work. We're going to talk about some of the specifics here, but just in the next few minutes, but just to give you a little bit of a preview, there are 9 states which are called community property states, where assets, unless it's documented separately, assets are considered equally owned by spouses. And so if you came from a common law state and moved into a community property state, understanding that how you documented your assets in your will pre-move into the community property state may no longer be valid. And so really just checking that. If you have a power of attorney already in place, there are 29 states that actually accept what's called the Uniform Power of Attorney Act, including Nevada and Texas. If you move, you need to make sure that the power of attorney you currently have is actually valid in the state that you've moved to. It may be that you need to put a new one in. The good news is that now 29 of the 50 states actually accept the same uniform power of attorney. And so hopefully you're moving within those 29, you don't have to document. We'll talk about state taxes, estate taxes, as well as inheritance taxes. But again, just being aware of where you're living and also where your beneficiaries may be living. So let's dive into these a little bit more. So on the estate planning side, kind of as you think about where to live, where you're living, really making sure you understand what your domicile is. So if you're someone who lives in a couple different states, maybe you live in Michigan during the summer and you go to Nevada or Arizona during the winter, really making sure you understand where you're domiciled from a tax perspective will matter for the will. Checking the property titling, particularly if you're living in a community property state. We talked about power of attorney, but really, again, reviewing those trusts and home ownership to make sure that as you're looking at moving, that you've factored in, what documentation needs to change to address the move that you're making. I mentioned community property, a couple states here that consider marital assets joint. So we have Texas, New Mexico, Nevada, Washington, Idaho, Arizona, California, and Louisiana. Oh, it looks like I've added Texas in there twice. But what I would just say here is just, again, really understanding, what needs to be documented. So it may be that you live in a community property state where typically if you're married, the assets are considered joint and they're split 50-50 in the case of a dissolution of the marriage. In that particular case, if you want the assets to be structured differently, you actually need to put documentation in place to ensure that the assets are split the way you're looking for them to be split. A couple things to think about as we think about some of the key numbers. We're just going to talk about some of the key tax thresholds. We're going to talk about gift tax. We're going to talk about state estate taxes, federal estate taxes, and then what are called qualified charitable donations. On the gift tax side, as you think about perhaps giving money to a loved one, remember that you can give in 2023 up to $17,000 to an individual without paying gift tax. If you are married, that means that you can actually give $34,000 to a friend, family member without paying gift tax. We're going to talk in a second about the state estate taxes. So depending on where you live, there may be a state estate tax. Federal estate tax right now is only for estates that are larger than about $13 million if you're an individual, or $26 million for couples. So those numbers are pretty high. The one thing I did want to flag is that, particularly for those of you that are thinking about giving money to charity, one of the really interesting things that you can do is you can actually use your required minimum distributions from your 401k to donate up to $100,000 annually from your 401k. So those numbers, again, are pretty high. But if you're subject to required minimum distributions, just know that instead of taking the RMD and then paying the proceeds to the charity, you can actually distribute directly to the charity and not pay that income tax, which is pretty nice. So let's talk about some of the differences in estate taxes depending on where you live. So I talked about the federal estate tax, which has this pretty high hurdle of 13 million and 26 million, depending on whether you're single or married. But there are 10 states that actually don't have their own estate taxes. And so important that if you live in one of those states that you understand the specifics of what those thresholds are for the estate tax on the state level. On the inheritance tax side, so think about that as the opposite side, which is who's receiving the money rather than who's giving. So the inheritance tax is the places where, for example, if your children live in Nebraska, Kentucky, Maryland, Iowa, Pennsylvania, or New Jersey, you need to be aware of these inheritance taxes. And so I think one of the things, without overcomplicating the situation, is not only thinking about where you're living, but also understanding where the people that are receiving your assets may be living to understand, whether they're going to be subject to taxation as a result of where they live. So one of the things that oftentimes is forgotten is digital assets. And this is kind of, I would say, it's like kind of we're kind of 2 decades in, but let's call it really a decade into kind of this digital world that we're in. And, a lot of your life is online, and really thinking about like, how do you make it easy for the right person to be able to close down accounts or access the information that they need in order to support your estate plan. So when you think about investments and savings accounts, making sure that someone in your life knows where the accounts are and is authorized to actually access them. That authorization can come through the power of attorney. So they'll be able to go to the bank with the will and the power of attorney and be able to do what's necessary with the accounts. I would just remind everyone not to forget about lock boxes. I know I don't personally have a lockbox, and my dad does. And so for him to remind me where the lockbox was and where the key is super important. And then retirement accounts, your family members maybe remember where you've worked the last 10 or 15 years, but they might not remember that first job out of college or out of high school, where you have those legacy retirement accounts. And so both thinking about consolidating those accounts, but also making sure that family members know where those accounts are will be important. Your social media accounts, understanding where you've got accounts and what all those logins are. I think about homes and utilities. You want family members to be able to shut off utilities when necessary. But we live in a modern world today where many of us have things like Nest doorbells, Nest thermostats, Ring doorbells, Alexas in our house, Yale locks on the front. So there's a lot going on there, and really making sure that the family members have access. If you think about like an electronic key, making sure that someone in your family actually has that code, and so that they're set up as a permanent access member to have a key code to your house. And then finally, the phone. Look, we all have different password management systems, and are in many cases use things like two-factor authentication. About really wanting to make sure that again, you've thought about that as part of your kind of digital estate that you need to document and put in a safe place so that the right person can access these accounts for you. All right, so I'm going to quickly refresh my screen for a second. We're going to go back into the survey, and then we're going to wrap up with marital status and go to questions. As I do that, I'm just going to ask if everyone can, again, questions that you have, feel free to drop them into the Q&A. So let's get back. Okay, so you're going to get back to me being able to share my screen. Okay, so a couple things that we're just going to kind of go through. So so at the beginning of the webinar, we asked a couple questions. So one was what percentage of the folks on the phone have a will? So 73% of you have a will. So great job on the pre-planning. Again, some of the early comments I made about making sure that you've taken a look at the will to make sure it actually is relevant today will be important. About a third of you don't have a will. So hopefully, as we've been going through this, it's helped you see kind of where a will might be relevant for you. I think this is interesting. So, we talked about when folks last reviewed their will. So for those of you that already have a will, only 10% of you have reviewed it in the last year. And so this is where I would say there's an opportunity just to take another fresh look. Take a look at that will every year, if not every couple of years. Really make sure that it still reflects what your plans are. And for the folks that haven't reviewed it in several years, I would definitely just take an opportunity after this webinar just to find a time in the next couple of weeks to take another review and see, are there any things that have changed in your life that would make you kind of rethink what your plans are. All right, so we had one last question there, which is who's using Retirement Simplified? So it looks like no one's using it yet. So I would just encourage everyone after the call to log into itcu.silvur.com. A lot of what we've gone through is going to be in Retirement Simplified. And so both the classes that we've talked about, but also the tools and calculators. And so you can set up your profile there. So let's, I'm going to continue on with just a couple of kind of marital status specific planning. And then we're going to do questions, and then we'll wrap up. So for folks that are single, and what I would just say as I go through all of this, what I would just flag for anyone that's in a partnership, really just have to understand what those rules are in your specific state to understand, like, whether your partnership is deemed, ends up with you being deemed to be single, or married, because depending on the specifics of your partnership and the state that you're in, you may end up in one category or the other. And so I don't want anyone who's in a partnership to think I'm ignoring you, but want to let you know that it is state specific, and the specific nature of the partnership will be important to really understanding which category you flow into. For folks that are single, I would just say to you that a power of attorney is really important, making sure you have thought about who you want to have power of attorney and what type of power of attorney. Specifically, having someone set up to provide that healthcare proxy is going to be important for you. Documenting what you want as far as type of care and who's able to make those decisions. Really making sure that beneficiaries reflect your current situation. As I mentioned, kind of in partnerships, if you're in an unmarried partnership, understand the role of beneficiaries, but also the community property rules, depending again on your state. Even if you're not married, but you're in a partnership, those community property rules can come into play. But if I was just to tap on one thing here for single folks, I would say power of attorney, specifically the healthcare proxy, being one of the most important things, so that you make sure you get the care that you want and the type of care that you want should you need it. Second group is married members. Here I would just say is really, create a plan that works for both spouses. It's rare that both folks die at the same time. And so really making sure that whoever outlives the spouse that passes first is protected. This is where I would say it's really helpful to retain flexibility, as one partner could outlive the other for many years. And so really making sure that the surviving spouse has been accounted for is going to be important. Keeping plans up to date as your family grows. If you're married today, but perhaps we're divorced, and so you are remarried and you have two groups of children from your first marriage, really making sure that that's been accounted for in your estate plan, so that you think about in this kind of new blended family that you understand what that family situation looks like. It also could be scenarios where, you've always been married to the same person and now you have grandkids, and has that been really factored into the estate plan? And again, here I would just say, as if you move, really make sure that you understand community property rules, that you've really thought about titling of the assets, that you've checked to see whether your power of attorney actually works in the state that you're going to. And then divorce members, what I would say here is really making sure that that your estate plan meets your intentions post-divorce. So if your will or estate plan was put in place while you were married, you definitely need a new will and estate plan now. If you're thinking about getting remarried, really making sure that you put a new plan in place that works for the blended family. And if you're divorced and single, this again is very much like the single members to start with, which is that power of attorney can really provide that peace of mind and ensure that you're getting the care that's most important to you. All right, so let's talk about, there's a lot that we've gone through today, and we're going to hit questions. But what I want to just do is make sure that we hit, I think one of the things that's challenging about estate planning often is that there can be this list that goes on forever of things to do. And so I want to just hit on what I think is the most important, and then we can hit on things that you can do down the road. So for the folks, the group on the phone that doesn't have a will, I would just encourage you to get that will in place. We'll talk about how In Touch in a second can help you with that. Assigning beneficiaries to your financial accounts. It could be that you don't have a will because you've done that. And so you may just say, look, I'm taken care of, but really making sure you've got those beneficiaries in place. Getting the power of attorney in place, particularly for healthcare, so you're protected. Really thinking about digital assets. It's this big category that often gets forgotten about. So making sure that the right person or people have access to those accounts. And then, I talk about the Advanced Healthcare Directive, which is really a version of a power of attorney, but again, making sure that's taken care of. I'm going to pause here and start taking questions. So let me, Rufus, if you don't mind, why don't we dive in and start seeing what questions we have? And let's get going.
All right, sounds good. If you guys have any other questions, please put them in the Q&A. But the first question we have is, can you set up a revocable trust that when you pass becomes irrevocable?
So by its nature of revocable trust when you pass does become irrevocable, because effectively like your death makes it revocable. So yes, or sorry, it makes it irrevocable. So the fact that you've actually set it up that way does actually work. The point is that during your life, you can actually still make changes to that trust, which is why folks really think about setting up a revocable kind of a revocable trust during their lifetime, because it retains some flexibility.
Our second question, in case anyone else needs to know, this is being recorded and we will send the link out in the next few days to everyone who's participated. So if you did miss some content, that will be available to you. The next question is, can we download the slides from the presentation so we can share with family member?
What we'll do is we will absolutely do that. The other thing I was going to say is that we have a couple of classes in Retirement Simplified. So if you go to intouchcreditunion.silvur.com, you can create your profile there, and you can also share that link with a family member, and they can access all of these classes plus classes on Social Security and Medicare there.
Okay. And then, can a trust be the beneficiary?
Yeah, so a trust can be a beneficiary. And so the way to, well, I guess the way I think about it is for your investment accounts, yes, you can set up the trust as the beneficiary and name them as the beneficiary for the account.
Okay. And then Sarah had a follow-up question on the revocable trust becoming irrevocable. Sorry. You said that there was no beneficiary protection from creditors from the revocable trust. So does that start to apply when it becomes irrevocable when you pass?
Sarah, this is one that I want to take a quick look at just to really make sure that we get you the right answer. So I think if you, when you logged on today, included your email address, what we'll do is we'll just follow up with the specific answer, because I just want to just check and to see where that creditor protection kicks in. So we make sure we get that right for you. Intuitively, what you're saying is correct, but I want to just triple check to make sure we get you the right answer.
Okay.
So Rufus, I think we had a couple other questions that we can address that I think kind of came up earlier. I think we had a question that was about what actually makes up an estate, because the word estate can seem kind of like a big question. And so estate is just a fancy word for kind of your investments, your assets, basically whatever assets you have minus debts and liabilities. And so it sounds like, estate sounds like you have to be really wealthy to have an estate, but the reality is all of us on this phone have an estate. It's just the legal term that's used to describe the different investments that we have.
Yeah. And then some additional questions. So are there any assets that can't be put in a trust?
Yeah. So this is a really good question. And I was having this conversation earlier today with a trust and estate attorney, because there's one big category of investments that typically can't be put in a trust. And these are retirement accounts. So 401ks, IRAs, 403bs, health savings accounts, and medical savings accounts. And that's because those are specific types of savings accounts that actually the IRS has set up for individuals to create. And so when you think about like a 401k as an example, for those of you that either are married or have been married, you may be aware that you actually can't merge that account with someone else. So that same concept of like why you can't merge your 401ks or your IRAs is actually the same kind of legal construct onto why you can't actually put those assets in a trust. So that's why in many cases you really want to think about putting beneficiaries on those accounts, because the benefit, basically when your estate is created and you pass away, the really effective way to get those assets to the right people quickly is to actually name a beneficiary. And those assets, while you're alive, cannot be put in a trust.
Okay. I know you talked about the makeup of an estate, and we talked about a little bit about what makes up, or what is probate earlier. But is probate a concern only for those with large estates as well? Because I know you talked about, putting estates and what, those types of assets in a trust, but what about the probate portion?
Yeah, so again, what I would just say is that probate applies to all of us on this phone, which is probate is the process by which the state basically looks at your will and makes sure that assets are distributed in accordance with your will. If you don't have a will, then the state has a set of rules that they follow that's typically based on relationships. So, spouse gets money first, then kids. Depending on the state, there's different ratios that they might apply. The idea behind probate is that that process can take oftentimes a year. And so by putting a beneficiary on an account, it allows that money to be distributed outside of the probate process. And so the example I gave earlier was, unfortunately these days, like funerals can cost a lot of money. So it's not uncommon for, by the time you pay for a plot, a casket, you pay for the actual funeral, you pay for food for family and friends, to find yourself spending $10,000 on a funeral. And that's a lot of money for someone to come up with quickly. And so if all of your assets are subject to probate, someone in your family is going to have to find that money to pay those bills. By putting a beneficiary in an account, you allow that family member to access the account and receive the funds very promptly. And so really the idea of putting a beneficiary in an account is to try to keep the assets outside of probate, and to make it, make it easier and faster for family members to get access to the cash like you want them to. And so that's kind of really what you think about. And again, I would say that no matter what your net worth is, thinking about beneficiaries, thinking about, what's the process in which, how quickly do you want people to get the money? If you want it to be this 1-year process, you could do everything through the will. I think for most people, that process just becomes very burdensome. And so, being able to set up the beneficiaries can be super helpful.
Okay. And I know for myself, so me and my spouse, we do not have children. And so we currently have both a will and a trust.
Yep.
That is currently set up for those things, and how to direct, our assets to be divided if both of us pass. Who should get a copy of those documents? Your attorneys will provide all of the legal advice, and they will most likely have, a copy of it. What family members, other than those that you've designated to make sure your wishes are carried out, should have a copy as well?
Yeah. So it's a really personal question, Rufus, where I would just say is you like to think about, like, who is that family member that you trust, that you want to have that information. So in my case, we were chatting earlier, I do have kids. And so we actually gave our will to the individual that we asked to basically be the guardian for our kids. There may be someone in your will that is going to receive kind of either that's going to be have power of attorney, or maybe you've got pets that you've asked to take care of the pets, or someone that's going to receive the proceeds of the estate, or primary share. And typically it's that person who's going to receive the primary share that you want to have that conversation with. And so that's, again, it can feel uncomfortable, but again, if you want, really want to bring them into the conversation so that it can create simplicity down the line, that's the thing that can make the most sense. The reason I don't have an exact answer is that you have to really think about, Rufus, for you and your spouse, like, who is that person in your life that you want to have it? It could be that they're not actually getting anything at all, but they're that trusted person that can manage the process for you. And I think it can be a real compliment for folks, right? People, like, when you ask someone to take power of attorney, to be kind of the trustee in this process, it's a real compliment to your thoughts on them as a friend, as kind of someone who provides guidance to you and your family. And so again, I think about that. Again, it could change. It could be that person 5 years ago, it's someone different now. And so you want someone else to have it. And so particularly if you're updating your estate plan, you're really making sure that, the person you think about today is the person that you're giving that copy of the will to.
Yeah. And the person that we did designate, does have a copy, but because we're a little younger, I guess I should say, our parents are both still living, and so they also have a copy. So, and we've discussed those things with them about what's in the content as well. So there's nothing that anyone should be surprised about if something happens. So we've done that as well, and we feel like we've made a good plan.
Yeah, and look, and I think because look, again, this is we all are part of families. There's parts of families that are simple and parts of families that can be very complicated. My understanding is, like, when I think about, like, the other thing that you can do is if you really aren't comfortable actually giving the will to someone else to read, is you let them know who the attorney is. And that way, because really what you're trying to do is make sure that if something were to happen, that folks can get the document that has your wishes included. And so whether that's handing it to them now, which could, bring on even more conversations, or letting them know, here's my attorney, like, at the very least, it's here's my attorney, so you know who to go to.
Yeah. We've got two more questions in our Q&A. The first one is, how do you go about getting a beneficiary assigned to financial accounts?
Yeah, so this is good, a good question. And Rufus, we might want to, after the call, we can send out a link to everyone who
Yep.
with their ITCU accounts, just to show where they can do that. I know, it's typically there's either a piece of like a one-page document that you'll fill out, or you'll be able to do it online, where you'll basically on every single
Yep.
account. So that's the kind of the little hassle factor here, is that for each of your providers and each account type, you'll have to fill out this document. But the document is very simple. It basically asks for the name of the account and who the beneficiaries are. I know for 401k accounts, it does not require a notary, and I don't believe that the bank accounts also require notaries. But what we'll do is we'll send out that link, Rufus, so that everyone can make sure that they have those beneficiaries assigned for their ITCU accounts.
Yeah, and if we're talking outside of ITCU, you'll want to visit with your financial advisor at those locations, because every financial institution's requirements are different when updating beneficiaries. There's some specific documents that you'll need, and some require a notary and some do not. So you'll want to make sure that if you have multiple accounts, that you please visit about that. The other question, I saw it right before it got deleted, so I can answer that. Someone asked about how they're just starting out on trust and estate planning, and could we direct them anywhere? And so Rian just brought it up on the screen for us. So here we go. In touch, we partner with Trust and Will. This $50 off plan for the estate is only through the month of August, so which means that ends today. That promotion ends today. So you may want to go out there and take a look at that. The web address is up there. I will also put it in the chat for you guys as well, so you'll have it. But there's a lot of great information out there that they can assist you with as well.
Yeah, and then like as I kind of bring the picture back together, this specific session today was really focused on folks that are either in retirement or nearing retirement. And I want to kind of just bring back and say that there's been a couple of folks here who've asked about how to get more information, and the best way to do that is going to be to go to itcu.silvur.com. You can create your profile in Retirement Simplified. To get started, you just need to give us your email address. And what we will do is we'll ask you a few questions about yourself. Are you married? Are you single? Where do you live? Really, so we can start getting you the right information to help you navigate your retirement. So, we talked a lot about how where you live impacts your retirement and your estate plan. And so, for example, in Retirement Simplified, we have a set of classes that are about retiring in different states. So retiring in Michigan and Texas and Nevada. We have classes on understanding the costs of Medicare. We have classes on understanding how Social Security works, on estate planning 101. And so, there's a lot more additional information that you can find in Retirement Simplified. In addition to creating the profile, what we will do is we'll provide you with updates on a regular basis around, what's happening that impacts your retirement. So for example, just this past week, the IRS announced that they're deferring some of the Secure Act 2.0 rules around catch-up contributions. For certain high income earners, the Secure Act said that starting next year, that high income earners were going to have to put catch-up contributions in Roth 401ks. They've just delayed that for a couple of years now. And so that's the type of information that in partnership with ITCU that we'll be sharing with you to really make sure that you can keep your retirement plans up to speed. But again, I want to say thank you for joining us today. Again, we have these new set of classes that are online that are estate planning based on your marital status. So single, married, divorced. If you're in a partnership, depending on what state you're in, you'll either want to read the married or the single lesson. You can easily access it by scanning the QR code, and we'll send a link out afterwards. But again, thank you for all of your time today. And we look forward to continuing to partner with In Touch Credit Union to support you on your retirement journey.
Thank you, guys. And like I said, we will have a recorded video of this coming up in the next day or two, and you will all receive the link. It will also be posted to our YouTube channel. Thank you, guys, for being part of our webinar series. Look for more invites in the next couple of weeks, and have a great afternoon.
Thank you very much. Bye-bye.
Thank you.